Do you have a loved one that depends on your income, or maybe a financial legacy that you'd like to leave to someone else? Keep listening as we dive into all things trusts. Welcome to the Money Meets Medicine podcast, where we talk all about the personal finance topics you wish you had learned in medical school. I'm your host, Dr. Jimmy Turner, and here is our co-host, whose better half is an anesthesiologist, and he's a father to two, Justin Harvey.
Dr. Turner, pleasure to be here as always.
Love seeing you, man. I love seeing you. I know. Actually, I think I got to know you before you had your first kid. Is that right? How old your oldest?
He's 4, so yeah, I think so. Right.
Yeah. It's exciting. But you've got a couple now. I mean, you're getting up there, man.
That's right. And there's nothing like becoming a parent. This may be a parent, but there's nothing like becoming a parent to want to address some of the estate plan questions. And and parenthood has a lot of challenges to it, obviously, and it's dynamic and multifaceted. And I was mentioning to you, I was watching Bluey with my 4-year-old the other day, who his thing is Saturday morning. If he behaves during the week, then we get a couple Bluey episodes on Saturday morning, which is fun. But the thing about Bluey, especially if you're a parent, there's that left hook that you don't see coming every now and then. And there was one about, parenting is addressed just as much as being a kid. And there was the 2 moms, and the one mom had 8, little dogs running around, and Bluey's mom was beating herself up about, oh my gosh, am I a good mom? And the mom of 8 tells Bluey's mom, there's something I need to tell you about how you're parenting. And I was like, ooh, let's get some parenting tips here. And here it comes. And then she sort of puts her hand on her shoulders like, you're doing a good job. And, being the dad that I am, and turning into an emotional, weepy mess in my old age, I was crying next to my 4-year-old on the couch, like, oh my gosh, I'm so hard on myself. And this was a moment of, we're all just trying to get by. And, sometimes the best you have to give that's good enough. And so as it relates to the topic at hand, an important way to care for your kids, to care for those that you leave behind, is creating the structure around your legal affairs when you die. And an important part of that is guardianship, which wills address. And then trusts have some additional sort of financial implications for your stuff, how it's handled, and the rules around it, which we can dive into now.
Yeah, no, I look forward to it. And I'm all about avoiding that shooting yourself into shame is what I call it. I should do this, I should do that. Mm-hmm. I think that's good. And also the mom guilt and the dad guilt is a real thing that I've definitely experienced. I should be spending more time with them. Oh, I talked about in the last episode, I should not be looking at my phone this much. So that's totally a thing. Before we dive into the show, March, time of the year, people start considering getting own occupation disability insurance, tying things up, particularly towards the end of training. As you're doing that, please make sure that you don't leave training without getting a quote on own occupation disability insurance. Your guaranteed standard issue policy, which doesn't look into your medical history, goes away within 3 to 6 months after you finish training. And so this is the time period where you really want to start looking into that. It's a really important topic. If you don't know what a GSI is, please go on the website, moneymeetsmedicine.com. You can submit the survey, get a quote. We'll give you all the information. If you decide to proceed, fantastic. If not, we love giving people education just like we do on the show. And you can find all of that at moneymeetsmedicine.com/disability. Justin, I'm going to be honest with you. I don't know a lot about trusts. I told you this on the show. And actually, this is going to be a very humbling episode for me because my youngest is now 7. I'm pretty sure the last time that I looked at my will and trust, it said something about future children, but she hadn't been born yet. And so my first 2 are on there, but my youngest is not, which makes me, again, speaking of parent shame, I feel like a bad dad on that one. Kristen kind of trusts me with this, estate planning, the personal finance stuff. And yeah. So I'm looking forward to learning a lot from you on this one.
Well, let me take this opportunity to say, Jimmy, in the spirit of Bluey, you're doing a good job. You're here. We're talking about it for our listeners. You're here. You can learn. You can grow. You can improve your circumstances. You can care for and love your family in ways that you're not currently doing. And that's something to be grateful for, not something to beat yourself up about. So
I feel like I need to pay you for a counseling session right now. It's just
yeah.
All right, where do we start?
So in terms of wills and trust, those are two different things. And I'm going to throw another disclaimer in, because I like to say that a disclaimer is like room temperature butter on a fresh slice of bread. It's hard to use too much. I love disclaimers, so I'm going to say I'm not a lawyer. I'm not an estate planner. I help my clients with their estate plans, and I ask a lot of important questions as far as how they want their affairs to be arranged. But then we work with attorneys to enact that, to create the documents, to create the will, the trust, the powers of attorney, the living will, all the end of life stuff. If you're dead, or if you're incapacitated in a hospital, there's a lot of legal infrastructure that can exist that will determine how your affairs are handled. What we're going to talk about today is a couple of those documents, the will and the trust. And I'll touch briefly on the will, and then we'll spend the majority of the time talking about trusts. A will, in general, determines what happens to your stuff that's part of your estate. And it will also determine guardianship of your kids. So when I'm talking to my clients about, if you don't have anything and you're going from zero to something more than zero, the best case I can make in many cases is, do you care who's going to raise your kids if, God forbid, two spouses die in the same car accident on the way home from date night and the kids are at home with the sitter? Is there any plan in place, or is there any understanding among your family? Or is it like one spouse's siblings and the other spouse's siblings or parents are going to go to court to try to figure out, they're fighting each other to try to figure out who's going to raise, little Johnny and little Regina. And if that's if you're okay with that, then I guess I will not be able to move you from that opinion. But if that sounds suboptimal to you and you want to clearly dictate in this formal document that you sign, your spouse signs, and you get notarized, and you put it on file with your lawyer and your advisor, and maybe you tell some family members, like, here's what we want to happen. That is a much less traumatic way to help protect your kids in the midst of what is admittedly terrible trauma. So yeah, putting guardianship. Yeah, go ahead, Jimmy.
I'll be honest that was the that was the thing that moved the needle for me, because I am historically, I'm getting better. I'm recovering at this, but I am historically notorious for putting things on the back burner that are just tasks, like life things that I need to get done. It's I need to go get my oil changed. That to me is just this giant stressor of I just don't want to do it. I don't want to make the appointment. I don't want to go through, and so and eventually the numbers get up there and they're I'm 200 or 300 miles over, and I'm a car guy. I actually do care about my car. I just hate doing oil changes. And so it was kind of the same thing for me with getting a will. It's I got to set up an appointment, and then I got to meet with the lawyer, and then we got to answer the questions. Then we got to come back and we got to sign things so that, once the documents are created. And so for me, there was a hurdle there that was a little annoying just based on my personality. But what got me over the hump was exactly probate. My kids going to court to figure out who's going to raise them and teach them, and give them their philosophy on life and their religious beliefs, and provide personal finance directives for them. I didn't want them to go through that experience. So I appreciate you mentioning that, because that honestly was the thing that got me to go, although I need to revisit it, as I mentioned, but maybe this is what's going to get me over the hump again.
Yeah, there are some strong psychological headwinds, and it's not just as you said, the life things. It's actually the death things that are often the hardest to deal with. I need life insurance, and I need a will. Just sitting down and soberly considering your death. Nobody loves to do that in general, and doing it with your spouse, creating alignment around very important values, discussions, and talking about oh, is it your siblings or my siblings? Who's going to care for our kid? That is really, it's not easy to do. There's emotional cost. And so for that reason, people tend to put it off for as long as possible. One of the best things I can do for my clients is force them to reckon with things that are very important. And, if they're honest with themselves, they really do want to deal with it. There's just some accountability is helpful there. Yep. So the will, it'll do guardianship. It'll also dispose of, which is a legal way to say allocate, where's the stuff going, that any probate assets, meaning anything that's not in a trust or a beneficiary designated asset. So whenever you die, anything that has a beneficiary attached, that goes to the beneficiary automatically. So life insurance, retirement accounts, those are two big ones. So that the will doesn't impact that. If you write a will and you say, I hereby leave everything to, my spouse, but you only have one life insurance policy and no other assets, and your life insurance policy has a beneficiary that's somebody else, they get the proceeds and your spouse gets nothing, even if your will says your spouse gets everything, They just get the probate assets, and life insurance is a non-probate asset. Same with retirement accounts. Something to add?
Yes. So I want to mention here for those people that are potentially divorced. So I know personal friends who have put a beneficiary on something. Let's, life insurance policy, their 401k, they put it on their pension, like whatever it might have been. And then they didn't change it and they got remarried. Right. And then when they died, all of their stuff went to the ex-spouse. And so like keeping up with who's on your beneficiaries is probably something that's reasonable to do once a year to make sure that like the paperwork hasn't changed, the system didn't screw it up, they left your kid's name off of it, or, whatever it might have been. But, I know we're mentioning this in passing, but like I know like very real life, true horror stories of people not making sure their beneficiaries are correct on their stuff. I say stuff very broadly, obviously.
Yes. I mean, I can only say 100% yes and amen. This is part of our revolving merry-go-round of this client service calendar. One of them is like, look at the beneficiaries for retirement accounts, life insurance policies. And it's also a good opportunity to revisit the offices of the will. So you've got an executor, you've got who are the beneficiaries, the people getting the stuff. You've got guardianship, and maybe you have trustees identified if the will is also forming a trust. And maybe the people you wanted to care for your kids last year, there was some blow up at Thanksgiving this year, and now you want to have it be somebody else. Those are all important facets of your estate that you want to consider periodically ongoing.
100%.
So the will determines who gets your stuff, your tangible property, your everything in your house, your collections of whatever, and anything titled in your name. And then if you have a trust, so now let's start talking about trust. A trust is like a separate bucket that when you put stuff in it, it goes outside probate. Probate is a legal process whereby a will is administered, and courts determine that, okay, if Jimmy wanted to leave everything to his family, and when Jimmy dies, he has this random person that comes out of the woodwork and claims that he is Jimmy's sibling, and there's a will contest, a contest of the will, meaning they're challenging the way that it was written, and they're saying, I want to be inherited. And I think that perhaps either someone else should be disinherited or there's an equal share or something. Probate is the process where they figure out, is this just some crackpot who has an axe to grind, or is there a legitimate legal standing here? Probate can take a really, really long time. Even if you have really no assets to speak of, it can take a year or more. And I've seen this happen firsthand. So imagine you've got $1 million that's in a checking account. You want to leave it to your kids. So you put in your will, I hereby leave the $1 million, all of my estate to my kids. If you have something that's just a checking account, that's split pro rata among your children, but it might take a really, really long time for your kids to get their $250,000 share divided by 4 of your $1 million checking account because of the probate process. And in addition, probate has a lot of paperwork, legal fees. You got to pay lawyers to do stuff for you. There's waiting, stop, start, make sure we don't miss this filing, all that stuff. And working with professionals to administer it. Often the cost it's related to the time, but it's also related to the amount of the assets. So the more you have that is a probate asset, the more annoying it is for your beneficiaries, and the more costly it is. Like if I got $1 million and I want to leave it to my kids, I want my kids to get the whole $1 million. I don't want them to get $1 million less probate, legal, and other fees. And so one of the ways that you can do that, well, there's a number of ways. A trust is one way to do that. And so putting it into the separate bucket, and it could be cash, it could be other things, it will become a non-probate asset, meaning it works kind of the same way that a beneficiary designation does for a life insurance policy, where when I die, if it's $1 million, the beneficiary gets the $1 million basically as soon as you can provide a death certificate. When a trust is funded, whenever the grantor, the person who creates the trust, whenever they die, the asset is disposed per the terms of the trust. So it's circumvents probate. It reduces the cost of administering probate. And it also, and this is perhaps the most important thing, if I want my kids to get their $250,000 each, they get it right away, or in an administratively much more compressed time compared to waiting until the estate is closed and cutting that final check. So I can actually get them the money timely, which If it's 1 year, if it's 2 years or longer, because you have a complicated, your long lost brother came out of the woodwork to contest or whatever, you eliminate a lot of that drama.
Yeah, it kind of it makes me think. And again, I'm learning on this episode, so this is fun. I've heard the terms revocable and irrevocable when it comes to trusts. I understand the process of like protecting money to avoid probate and that sort of thing, but it almost reminds me of like some of those just the terms that are used. It reminds me of some of those like savings accounts that you use for like UMTA versus UMGA versus 529 and like naming children, and then like once they're named a beneficiary, you can never take it back, like depending on which kind of account you use. Like the words irrevocable and revocable to me scare me a little bit, just because like I hear irrevocable and I'm like, okay, so that means that like if little Johnny, after when I die, decides that he wants to blow all his money on, like I can't like, I don't know. It feels a little strange to me. Like, why would you ever consider an irrevocable trust, and like, or is revocable just what everyone always does? Like, I don't, seems confusing to me.
Good question. So I'm glad we're on this topic. So trusts can be broken down into two categories, and there may be other sort of esoteric options, but fundamentally we're talking about irrevocable and revocable trusts. And it's just the way it sounds. An irrevocable trust is something, once it's done, it's done. It's out of your control. It's out of your estate. It's administered by a third party, not you. Now, in some cases, it could be someone who's close to you, depending on personal circumstances. But it is functionally, you've given away whatever is contained within the irrevocable trust. Most of the time, for especially like families who are in accumulation mode and they're wanting to designate assets but not give away and lose control of the asset, we're talking about a revocable trust. That's REV, revocable, not irrevocable, IRREV. So revocable, also known as a living trust, also known as an inter vivos trust, because why would we have just one name for something if we can have three names for it?
Medicine.
This is a trust that, yeah, exactly. It's a trust that you can change your mind. You can fund it. You can, once you create the trust, it's an entity. You can title things in the name of a trust. So you can title your checking account in the name of the trust. You can title a brokerage account in the name of the trust. You can have a trust as beneficiary of certain accounts. You can have a trust as a beneficiary of a retirement account, of a life insurance policy. Now, there are complexities, especially with retirement accounts. You want to make sure you're working with an estate attorney to make sure that your trust is properly structured to receive IRA and Roth IRA assets in particular. But it's you maintain control. So you have a trust that says, I want there's three beneficiaries for my trust, and I have three kids, and each kid is going to be entitled to 1/3. And I've got a bunch of things titled in the name of a trust. I've got some cash accounts. I've got some investment accounts. So when I die, assuming I'm a single parent, we'll assume to keep things simple. So there's me. I've got this living trust, a bunch of things titled in the name of the trust. I die. That living trust becomes an irrevocable trust. So it's upon my death, it can't be altered anymore. It's now a trust that is its own structure that has the beneficiaries attached to it. It's administered by the trustee or trustees. It is the trustee. It's their job to make sure that the trust operates according to the design of the grantor. The grantor is the person who creates the trust. Go ahead, Jimmy, jump in.
That one makes sense to me, right?
Okay.
And
right.
By the way, I'm kind of laughing at you, like revocable or revocable. I need to there's got to be like a Oxford Dictionary way that like that's supposed to be pronounced. I got
sometimes the Oxford Dictionary doesn't solve these. I bet it's both.
Who knows? Anyway, it makes sense to me that like you transition from one to the other upon your death, and like I just don't. I don't know why I would ever want an irrevocable trust.
Yeah, well, imagine you've got $100 million, and the estate tax is going to start kicking in at $26 million currently, and there's an upcoming sunset, and there's these limits are shifting, but tax avoidance is an important facet of an irrevocable trust, where once you fund an irrevocable trust, that money's out of your estate. Now, there are other ways to do this, but if I wanted to maximize the amount of money I get to my kids, an irrevocable trust would reduce the tax burden on my estate, because if I'm worth $100 million and I fund an irrevocable trust with a bunch of that, the tax burden on what remains goes down. Now, the significant downside to that is you lose control. So the way that sometimes this works is, well, I'm going to make my brother the trustee. And my brother and I, we have a good relationship, and my brother knows what I'm trying to do here. So I'm going to create a trust, wink, wink, nudge, nudge. Like I can basically still call the shots. First of all, the IRS doesn't like that and will be knocking on your door if they deem that there's not an arm's length relationship. And if you're still functionally the trustee of an irrevocable trust, that is not permissible. But the other problem is sometimes you've got that weird blow up at Thanksgiving where his wife says something to your wife and all of a sudden he's pissed and he's in charge of the $50 million you seeded into the irrevocable trust. So now legally it's your brother's decision about what happens there. So There's this balance of how do we reduce estate taxes over time and maintain sufficient control. I have my own philosophies about this, and obviously this is something where I need to solicit input from my clients in terms of what they want to do. And it seems kind of abstract if we're talking about you can pass $26 million to your kids jointly with you and your spouse without a federal estate tax happening. But there have been times when this is much lower. And frankly, we're both in our 30s, I think, Jimmy. There will be a time probably, if we live long enough, it may again become like $1 million or $500,000. And then all of a sudden there's a 40% estate tax. As the political pendulum swings, this is something that happens. Now imagine you're a physician, you've been making good money, you've been diligently saving that money, and you've got an estate of $10 million as an 80-year-old. Do you want everything, $9 million above that threshold? Do you want that to be taxed 40% to Uncle Sam? Now we're sort of talking a more, you can see where this, some of these strategies might come into play. So
I totally get it.
But what's more common, especially for early career or even mid-career physicians, is the revocable, the living trust, where you would set up the trust, you would create some rules around it, and then you would fund it. So a trust is only useful if you fund it. If you create a trust and you don't have any assets titled in the name of the trust, and you don't have the trust as beneficiary of any assets, then you paid a lawyer a few grand to do a thing that you just never really used. And then all of your assets are going to be passed either according to beneficiary designation or according to your will. Go ahead. Something to say?
So it becomes pointless. No, it makes sense to me. It's something that would exist. I mean, it's like creating a company and then never like putting money into the company's bank account and not having any IN and
And this is an area where it's useful to work with an advisor because lawyers get paid to create trusts. They don't get necessarily paid to like ensure the proper execution of the strategy is completed. So if you're working with someone who has a longitudinal relationship with you, and frankly, I have people come to me not infrequently and say, yeah, we gave a bunch of money to a lawyer. They did a bunch of stuff. Here it is. We haven't done anything with this. We set up a trust 6 years ago, and we haven't ever funded it, and we haven't ever updated any beneficiaries to reflect this kind of complex, kind of expensive estate plan. So that accountability function for an advisor can say, all right, like let's go back to the lawyer, say, what do we need to do to make sure this happens? And then we do a bunch of paperwork to have it reflect the very well thought out strategy that was created by the attorney.
Yeah.
But funding is necessary. So once you have meaningful taxable assets in particular, in some cases, real estate is another one. This asset is not going to circumvent the estate tax. So if estate taxes were, if the ceiling that's at $26 million was all the way down to $1 million, and we had $5 million in a revocable trust, when I die and that trust becomes irrevocable, that $5 million is still going to be subject to estate tax, anything above the sort of the carve out limit, but it will not have to pass through probate. So there is an estate tax that will be levied, but we are going to save costs in terms of the legal fees and the waiting game of getting the assets into the hands of the beneficiaries. This is particularly useful. The guardrails created by a trust are also particularly useful for younger, whether they're actual children or your kids who are perhaps adults, young adults, because you can create some restrictions. And this is true for irrevocable trusts or revocable that become irrevocable. You can create restrictions, some strings attached on how assets are used. There's what we call the common nomenclature is health, education, maintenance, and support. So if you're creating a trust, you might see this phraseology in the trust document that you create. It means like if my kid has a medical emergency, if my kid wants to go to grad school, if my kid needs to pay their rent, and whatever support means. It does get a little bit squishy, and you kind of want it to be squishy. Like, what if my kid receives money in trust and they want to start a business, or they want to, travel Europe for 6 months? There are some kids who, if you're 27 and you're in between jobs and you're a trust fund baby, which is kind of what we're talking about, if I'm the parent, there are some kids who, that 27-year-old can responsibly have 50 grand to live in Europe for 6 months. And you would want that as part of their enrichment and education. There are other kids who should not be trusted to do Europe, in air quotes, for 6 months. And this is where the judgment, the discretion of the trustee comes in, because the trustee has the ability to allocate money for health, education, maintenance, and support. And they have the ability to do it not equally. Not that it's inequitable, but it's not the same necessarily for the 4 kids that you want to get some stuff, some of your collections or some of your cash or some of your investments or whatever it is. And so there is protections in place where, unless it's, it's got to check one of these boxes, and if the trustee says no, then the beneficiary is out of luck.
Yeah, and I think that, there's some reason, some benefit, right? You're mentioning young children. If they're less than the age of 18, having this money kind of set aside in a trust directed by the trustee, is obviously beneficial, because they probably, are not in a situation or an age in which you should inherit $3 million or whatever it might be.
That's right. So it's true for the 12-year-old who you don't want to have $3 million, but we all probably know some 33-year-olds who act like 12-year-olds, and the same protections are in place for them. And you, as a parent, I care about my kids. So if we make this personal for a minute, if I die when my kid is 22, it's a beautiful thing to need to work for a living, to have a vocation that you use to make the world better. If you remove the need to work from your kid, you're not really helping them. You're going to make them into a human that is not the highest form of human, in my humble opinion. This is just me talking. So if I had $10 million, I wouldn't want my kid to not have to work for a living. And I would have rules in a trust, if they were an inheritor, that would make them still have to work. So a trustee is maybe going to make sure they don't starve to death. But I'm not going to say, hey, it reminds me of the movie. It's got Hugh Grant in it, and his, what's it called? This is going to bother me. It'll come.
I'm not going to be helpful here. I can tell you that.
It's he is a trust fund baby because his dad wrote this like little Christmas jingle in Great Britain or something like that. So he's, interacting with these girls on a date or whatever. It's like, oh, so what do you do? It's like, well, it's like, the song. Da, 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 da. It's like, well, actually, my dad wrote that. So what I do is I'm a trust fund baby, and I have this money from this little Christmas jingle that my dad wrote 50 years ago. And it's just the perfect expression of like, yeah, once you lose the need to contribute, then there's nothing to motivate you anymore. So anyway,
yeah,
it allows that to happen. And for the 33-year-old who, even if you're responsible, another benefit of having trust protection is that 33-year-old is going to get married, is going to have kids. That 33-year-old maybe is going to launch a medical practice. Maybe through the stress and strain of launching a medical practice, that 33-year-old spouse is going to divorce them because they get pissed off because they spend all the time thinking about their business and none of the time thinking about the marriage. And I know that this is totally a foreign concept to everyone in this audience. If that happens, there is protection potential. I mean, this is a very legal question, but the asset that is a pre-existing trust asset is not going to be subject to the same rules of asset division as anything else that you accumulate during the course of your marriage. And so if you got $50 million in a trust fund, or maybe it's $3 or $5 million in a trust fund, and your spouse, I'm assuming a charitable example, we could also use the gold digger example of like, oh, they're worth a lot of money, I'm going to marry them and take them for half. Anything in trust is going to be, even without a prenup, and again, I'm not a lawyer, so talk to a lawyer about this, but even without a prenup, that asset is going to be protected. Similarly, if you are in your car and you rear end someone, or if someone slips and falls on your front door, or somebody gets hurt in your medical practice and there's a judgment against you for a negligence or medical malpractice, in any of these cases, this asset is going to be different than the money in your checking account and different than anything that is owned fee simple, as we call it, which means in your name outright. Those assets would be subject to seizure and subject to judgment and subject to division, but assets held in trust will likely, again, I'm not a lawyer, will likely be protected because it's just a totally different animal. You don't even have control of those assets. you're a beneficiary, but you can't just do whatever you want to with them. And therefore, your credit card company can't come after them. The plaintiff's attorney can't come after them. And it provides protection for all those reasons.
Yeah, no, I think that's super helpful. And to be honest with you, Justin, like as I listen to you on the show and chat about this, it makes me want to go and like check on my own stuff. And so it's a little bit of a bluey moment for me having to, go through this. And I hope that listeners, as you listen to this episode, you kind of had a similar response. If you have children, family, a legacy that you're leaving, the importance of having this conversation with an estate attorney, and really kind of hammering these things out. I do think it goes on the list of, financial tasks that you have to check off. Obviously, having a financial advisor would be beneficial in this situation. If that is something you're interested in or the situation that you're looking to have, I think that but again, this is an important topic. And as you're talking about these things, I'm like listing off in my head the things that I know are not, beneficiaried by a trust. Like the trust is not a beneficiary of that asset. Like my brokerage account is a great example. And so, as you're talking about this, and I'm like thinking about malpractice opportunities or maybe the opposite of that, or a variety of other things that could happen. And yeah, this is a conversation I think all of us should visit, myself included.
Yeah. And it's just one tool. So and we can close on this, is one of the phenomena I experience is people come and people bring this to me. I was in the OR and I heard the surgeon talking about this, or my buddies in the doctor's lounge were talking about that. And like, I need one. Like they have this and they're reducing their taxes and I need one too. And a trust is just a tool. It's a tool that's part of a comprehensive risk management strategy and tax reduction strategy that you need to like look at the big picture, because there's a lot of ways to limit risk. You maintain insurance on your car, you have an umbrella policy, you have a med mal policy, you have entities in your business to segment risk. And they're all important. And a trust can be one tool, but it's not a fix all. It's just a tool and needs to be used in conjunction with all the other parts.
Yeah, love it. Well, everybody, thanks for listening to the show and appreciate being part of the Money Meets Medicine community. If you are so willing, go check out the show on iTunes, leave a review. It's super helpful for people finding the show. And Justin and I would love to hear about how you think we're doing, since, I don't know, Justin, you've been on the show for 6-8 episodes at this point. So you've got feedback, comments about, how amazing we are. Please leave a 5-star review. If you think we're terrible, email Jimmy@moneymeetsmedicine.com and I'll make sure to delete it. Otherwise, we will see you next week. Cheers. Justin Harvey is a certified financial planner at APM Wealth, where he helps anesthesiologists and pain medicine physicians. Dr. Jimmy Turner is a practicing academic anesthesiologist at Wake Forest in North Carolina. He's also a licensed insurance agent. However, neither Justin or Jimmy are your financial planner, investment advisor, or insurance agent. This show is expressly for general education and entertainment purposes only. Nothing should be considered financial advice. All views expressed are solely the views of the guests on the show and do not represent the views or opinions of their employer.